Good morning and welcome to another presentation. In this short presentation I'm going to talk about information which you may need to know if you have to appeal a court case. Although this particular presentation deals with UK court, it applies universally across all of the court systems. One person had asked me before, or made a comment, and said, well, people don't win against council tax. That's not entirely correct. So I'm going to give you a few court cases and some other information which will help you. In 2019, a landlord in Birmingham won an appeal against the Birmingham City Council, successfully arguing that he was not liable for council tax on property that was unoccupied or undergoing renovation. The court ruled in favor of the landlord, stating that the property was not habitable and therefore not subject to council tax. Another court case, a homeowner in Scotland challenged their council tax ban, arguing it was incorrect. The homeowner successfully appealed to the Valuation Appeal Committee, which lowered the council tax ban and provided a backdated rebate. And then I gave you the link which you can write down and go to for more information. Another court case, a homeowner in England disputed their liability for council tax, arguing the property was not habitable due to major repairs. The homeowner successfully challenged the council decision, and the court ruled in favor, exempting the property from council tax. I provided a link on how to do the appeal to this valuation ban. Now, I can't guarantee a success in every court case that you do. I'm not responsible for your paperwork. If your paperwork is done incorrectly, or maybe if it is even done correctly, it is the ruling of the judge. However, I do have a remedy, and I'm going to cover that in this presentation. Another court case in 2016, a landlord in Leeds won a court case against Leeds City Council, successfully appealing the council's decision to hold him liable for council tax on property that was unoccupied and was still under a valid tenancy agreement. I provided the link for your perusal. Another court case, a non-resident landlord in the UK won a tax case against HMRC, successfully arguing that they were not liable for capital gains tax on the sale of UK property. The court ruled in favor of the landlord, stating that the property was not subject to CGT due to the landlord's non-resident status. This may help somebody that has property in the UK that's being subject to this capital gains tax. Another court case involved judicial review where council tax payers, notice I said payers, which is plural, challenged the council's decision on increasing council tax. The High Court found in favor of the council taxpayers, ruling that the council had not followed proper procedure in consulting the public before implementing the tax increase. You may remember in a previous presentation I talked about the fact that councils are raising council tax in some cases 25, 30, 40, or 50%, which is far beyond what they're allowed to do without announcing it to the public and getting the public's input. This information alone on this one case should raise some eyebrows and hopefully some action regarding the unlawful council tax values being raised. Now, courts are generally obligated to follow the ruling from a higher court, and you'll notice I put a number 1 here. That's because later in this presentation I'm giving you the links to follow up further information on these specific situations. Courts are generally obligated to follow the rulings of a higher court within the same jurisdiction. This principle is noted as stare decisis, or precedent. Here are the key points. Hierarchy of courts. In most legal system, courts are organized in hierarchy, which the higher courts have the power to review and overturn decisions of the lower court. By that same token, lower courts are obligated to follow the decisions from the higher courts. This saves wasting courts' times and a bunch of appeals. Now, if you noticed my cases I presented earlier in this presentation, were all based on an appeal, or at least most of them were. This would mean then that if you challenge the council tax, you may have to appeal your court case to the higher court. And again, as I've stated in a previous presentation yesterday, you may do one of three ways. You may do a judicial review, you may simply file an appeal, or you may go to the valuation band. In this slide, I present the courts are generally obligated to follow the ruling from higher courts, and this is number 2. Binding precedent decisions made by higher courts are binding on the lower courts within the same jurisdiction. Lower courts must follow the legal principles established by higher court rulings. This is why I state that if you are working on any particular court case, it is always best to find court cases from a higher court, higher than the one that you're in. Courts are generally obligated to following higher courts. Number 3. Persuasive precedents. Ruling from courts from other jurisdictions or from courts of the same level may be considered persuasive precedent. Lower courts are not bound to follow them, but may do so if they find reasoning. Now, this is applicable because there's a court case, Meads versus Meads is one example. It's from Alberta Queen's Bench, and that court case is used in cases throughout the world for people who try to make what's called free man on the land arguments, or opto pseudo litigant arguments in court. That is to say that if you find a case that's in another country that's from a higher court, you can bring it into a lower court, even though it's from another country, but it's only persuasive. They're not obligated necessarily to follow it. And this answers a question from one of the viewers that said, well, can we bring in court cases from the US or from the UK or from Canada into a different jurisdiction? So, for example, Meads versus Meads is the Alberta court case, and it's been used with the UK courts when people try to make arguments that the UK courts don't like. On the same token, I can bring in a US court case into Canada, even though it's not the right jurisdiction. It's persuasive to the court. That should answer that question for anybody that's been questioning whether that's valid or not. A court case reference number 4, distinguishing cases. Lower courts may sometimes distinguish the facts of a case before them from a higher court precedent, arguing that the legal principles established in the higher court case does not apply due to factual differences. This is why when you bring in a court case from a higher court and attempt to use it in a lower court, you have to verify before you bring that argument forward that that court's case is in fact relevant based on the same principle concepts or arguments. Just throwing some higher court case in there which doesn't have the same context is not necessarily going to even be considered. Courts are generally obligated to following rulings from higher court. Number 5. Overturning precedent. In some circumstances, a higher court may overturn its own precedent, but this is very rare and usually only done when there are compelling reasons to change the law. Notice I said change the law. Precedent court cases set precedent and therefore establish law. So in summary, the system of precedent or stare decisis is fundamental to common law legal systems. Therefore, it would apply to all of the British Commonwealth realms. It provides consistency and predictability in the application of law. Lower courts are bound by higher courts' decisions in the same jurisdiction, ensuring the uniform development of the legal principles. I will leave this on the screen for a moment, and you can write this information down if you wish to verify any one of the 5 statements I've made previously, and I will continue very shortly. I will leave this on the screen for approximately 10 seconds. Feel free to pause the video if needed to write this information down. What do I do if a court does not follow the law? The principle that courts must follow the law and legal procedure is fundamental to the rule of law. If a court acts outside its legal authority or fails to follow the required procedure, its decision could potentially be challenged and overturned on an appeal or a judicial review, as I've said earlier. Now, I've given you a court case here. You can write this down. The court case of Kafka versus Oldham in 2024 confirmed that laws made by Parliament are binding on all, and individual consent is not required. This suggests that courts are obligated to follow and apply statutory law. Now, in many of my presentations, I've made the arguments against council tax, and council tax is in fact done through the Local Government Finance Act and the enforcement regulations therein. Therefore, based on this Kafka versus Oldham 2024 court case, if the court doesn't follow its own rules, then you're not obligated to follow that court ruling. It has no legal force and effect. Similarly, in Belleville, Ontario, I was involved in a court case, two court cases in fact, one in Toronto where Justice C. Dunphy did not follow the law, in fact didn't care about court procedures or anything else, and therefore his judgment is null and void. At the same time, I also dealt with the court case that was running in parallel for the same alleged offense with the city of Belleville, and in that case the presiding judge, operating out of Ottawa because it was a conflict of interest with the local court, because I knew most of the judges in that court when they were lawyers, and so did the city solicitor. The judge there, Ryan Madeline Bell, did not follow court procedures. In fact, disregarded the fact that the city solicitor stated that they could not file a defense based on my case, and therefore I would have won my case. Similarly, the Toronto court case dealing with Sean Dunphy, also the city lawyer did not file a defense, and therefore the court operated again outside its legal authority. Now, once a court operates outside its legal authority in any jurisdiction, the court loses subject matter jurisdiction, because why would they still have authority if they didn't follow the statute or the rule of law? The same thing happened in a court case involved in the UK involving council tax. In fact, this happened many times. Now, I bring you to another court case in Manchester Magistrates Court versus Mackenzie 2015, an individual who tried to use the free man on the land type arguments against following the laws ended up being jailed for contempt of court. This indicates that courts will enforce statute and procedure. Now, this leads you to a conclusion then, that if the court must follow the statute and procedure based on this Manchester Magistrates Court versus Mackenzie, I would argue the fact that if the statute applies to the individual, right, you and me basically, it also applies to the court, and there is court precedent that states the law must be applied equally. If you want to look that up, you can certainly review my legal maxims presentation, which I've done previously, which is on my YouTube channel. So, by using the arguments presented in this slide presentation here today, we can now build an argument and a case against council tax, property standards issues in Canada, or any other court case that happens to not follow court procedure. So this application now can be applied to both the UK, the US, Australia, Canada, and the United States. Now, I bring you another court case, Ashby versus White. In the 1703 case of Ashby versus White is significant in court rulings because it establishes the principle of injura sin damno, which means that the infringement of a legal right can be considered an injury even if no actual damage or loss incurred. This principle has been influential in the development of tort law and has been cited in various subsequent cases. In the cases of Ashby versus White, Mr. Ashby was denied the right to vote in an election due to misfeasance of a constable. Mr. White, although the candidate Ashby wanted to vote for won the election, Ashby still sued White for the infringement of his right to vote. Now, that's a simple right to vote, and I would make the argument I don't think voting makes any difference, because if you logically apply common sense. If a party has control of the government, then I don't think they're going to let anybody in there that they don't have control of. But if we can use this Ashby versus White case on a simple argument of the right to vote, I would state we can also apply the same argument that if the courts have denied you your fundamental rights, then you have every right to appeal that or challenge the individual that took away those rights. Now, the court ruled in favor of Ashby, stating that his infringement of a legal right is sufficient to constitute an injury even if no actual damage occurred. I would say that same argument applies in any court case that denies you the right to have a fair hearing. This principle has been established in various contexts, including voting rights and the protection of civil liberties. It emphasizes that the law should provide a remedy for the infringement of a legal right, even if no tangible harm is suffered. The significance of the Ashby versus White lies in its establishment of principle that an injury can occur without actual damage, and that the law should provide a remedy for such injuries. This principle has been influential in shaping the development of tort law and continues to be cited in all relevant court cases. Again, I would state that would apply to anybody dealing with unlawful actions on by law enforcement officers in Canada or other jurisdictions, Ontario for example, or a person that's been infringed on their rights given the council tax arguments.